Ron from Ron Rohde Law, and together with ACRE, we're going to be walking through this standard industrial triple net lease. This is really a fair lease. If anything, it might be slightly biased towards the landlord, but we're going to do a walkthrough and go through every provision just kind of in real time. So if you have any questions, feel free to drop a comment. All right, again, the title, some people ask me, does the title actually matter? And from a legal purpose, no. You know, this can say triple net, or it can just say lease, and it's up to a court or the parties to interpret what it really means, because triple net is really kind of a broad term. So while the name can be useful and certainly guiding intent, it is not controlling in terms of whether the lease is actually a triple net. You know, first things, name the parties. It's really important that the landlord is properly named. LPs versus LLCs, corps, if there's a manager. The actual deed record owner needs to be the landlord. The tenant, again, needs to be the entity that's going to occupy the space. If you're a landlord, it's important that you properly name the business operating entity or somebody that has a contractual right to perform business. Notice addresses, these are super critical. Later on in the lease, we'll see what type of notices need to be mailed versus copied to, right? So what this means is notice is not sufficient if you only mail it to the landlord. You will also need to mail a notice to say this is for the attorney and as well as by email. So we'll get into that a little bit, but it's really critical that when you're trying to comply with the terms of the lease, that you look at the notice section and fully comply with all of these notice provisions. Property address, this is typically a street address, but is not really defining what the leasehold is. It's really just kind of a quick point of reference, and the particular description, which is going to be a legal description, maybe a survey, that's really what's going to guide the actual leased premise. The building, again, if you're not dealing with a single tenant, you know, you want to specify a suite or a portion of the building within a larger building. If it's an industrial complex, it really can get complicated. If you have a single owner that owns 6 buildings, you know, which building are you leasing? Square footage, approximately, we get into that a little bit later, but you just want to describe it for purposes of general discussion. Premises here, this is, you know, suite A, consisting of a portion of the total building. Lease term, we typically denominate these in months. And there's a little bit of language here. It depends on how you want to deal with partial months, but pretty standard. Renewal options, you may or may not have this. You know, I'm seeing a lot more landlords now in this industrial market. They don't want to give any renewals. Even if it's at fair market, they think that there's a better opportunity to sign for really lucrative rents. And it seems like every single lease signing is setting a record for new lease rates. And so shorter lease terms with no renewals are really becoming the trend to really jack up those rents. Commencement date, again, usually we define this as the later of, if there's TI or a later date occupancy. Security deposit, you may or may not have this. If you have a credit tenant publicly traded with a parent guarantee, you may not have that. Permitted use, you know, this is pretty important where we start to describe what is the tenant going to be doing. You as a landlord, you have to think about harmonious uses. Maybe you have trouble with the city, the state, and so you really want to know what is this person going to be doing in your building, and that's really the scope of their permitted use. Guarantor, again, you may have a personal guarantee. I see personal guarantees, you know, on fairly large leases. It really just depends on the business, how long it's been around, how much of non-family management is there, and so it's perfectly normal to see a guarantor even on an established business. Again, just depends on the perceived tenant risk. And you may have a burn off. You know, that's something that your lawyer can draft up as a reducing amount of a personal guarantee, either over time or after a certain number of payments are made, that sort of thing. Base rent, again, we repopulate with square footage, and you really just make it straightforward. And so it's critical that these calculations are accurate. Your lawyer will typically do this. I don't do it with the broker, but they could. And you just want to calculate everything. You know, this looks like here's 5 years, 6, so 7-year lease, pretty standard. Allowance, this is regarding a TI, tenant improvement allowance. You either can do a fixed dollar amount, you know, it's still pretty common to say, we'll give you 100 grand, you use it however you want, that's it. Or we give you $3 per foot, and that allows you to maybe compare lease proposals from different landlords. Early occupancy, pretty standard. You just want to make sure they're not charging. This doesn't trigger the commencement date. You don't have to pay rent. But if the building's done, if it's ready, I think it's a sign of good faith to let the tenant in there early. Again, schedule. So we have rules and regulations. We have the legal description of the property. We have depiction of premise. This is usually a site map. And so it'll be the interior walls, a bathroom, office, garage, that sort of thing. And then they typically would do like a crosshatch of the specific area if you don't have a single tenant user that's occupying the entire premise. Broom clean definition. You know, that's really important that we define what this building should be returned in, what they're receiving it and what they're returning it. Repair requirements, again, super critical for triple net leases. You need to identify what the tenant is responsible for and what the landlord is. Because even if it's a triple net lease, sometimes the landlord is still responsible to maintain the parking lot, to maintain the roof, maybe all the outer membrane exterior of the building. On the other hand, if it's an absolute, like a true absolute triple net, then the landlord really isn't responsible for anything. You know, the building is completely in the hands of the tenant. And so it's just important to understand what type of lease are you envisioning? Is it an absolute single tenant net lease like the Walgreens or a CVS type of lease? Or is it more of just a warehouse with a large tenant that is responsible for everything but the roof, everything but the parking lot, foundation, that sort of thing? Tenant work letter just describes what they're going to do. Lease guarantee, if applicable. So again, I'm going to kind of go through these things with comments on what kind of jumps out to me as non-standard. It's not quite going to be a robust line by line every single item, but if you're looking for something like that, contact me. I can make another video. I can do a consultation. Accept the premise as is, that's pretty standard. Business hours, you may want to define. A lot of tenants want 24-hour access. That may not be compatible with the city, with your industrial park. So again, the business hours and hours of access that they can make noise if they're manufacturing, all super critical that you match the lease with what you envision for your building. Here we have limitations, compliance with ADA, no public accommodation, right? So this isn't open to retail customers. Base rent, prepay, late charges. Again, 5% of overdue. That's pretty standard. Could be more. It could be less. Everything is additional rent. That's important for evictions or for later judgments when you want to compile all of your charges as rent so that you don't have a judge discretionary removals reducing the amount of an award, of a monetary award. These are just definitions. These are definitions that matter, but I really can't go into everything. This one has a reasonable management fee. That's a little bit different. Not every lease, not every tenant is going to let you do this, 4%, and they're paying for it. There's plenty of triple net leases that the tenant do not pay a property management fee. If it's single tenant, you may just self-manage, and so it kind of makes sense why they don't want to charge, but just something to be aware of. These are exclusions. So I think the key for operating expenses is to really name every single type of expense and put it in a category. Covered by the tenant, not covered by the tenant. And try to name as many as you can. I think clarity is the best way to avoid bad feelings. Tenants get upset if they feel like they're being overcharged. Landlords get really upset when the tenants refuse to pay. So it's in your interest to really just be very clear on these sections, because I see probably 70% of the disputes have to do with CAM and OPEX chargebacks for a triple net lease. That's probably 70% of the disputes. Estimated taxes, again, just make sure you have a mechanism for a re-estimate, maybe an audit. That's very common, but you want to make sure the tenant pays those costs. Maybe they can only do it once per the term of the lease, once every 5 years. They can't be auditing every single year. That's not reasonable. Utilities, insurance, again, choose a number that makes sense for your lender if you have a lender on your property. Also based on the use, the size of the building, but $2 million, $5 million is pretty good. That's going to cover a lot of buildings. And it's kind of like measuring how many people could get hurt at once. So maybe 2 and 5 million is good for the building. It's going to have to be a judgment call. Again, here we have the obligation of the tenant to deliver such policies. you can set the time, you can send how frequent, and you can really specify the penalties if they don't get it to you within these 10 days. A lot of leases are kind of silent on that, and it's just kind of a soft default, not really a default, not a material breach, but it can have some penalties in there. Services and repairs, tenant repairs, again, it just really talks about what do you have to do, when do you have to do it, and what is the recourse if you don't. That's really kind of a simple summary of these types of obligations, but it is a building, and most of these are passed over to the tenant, but exterior plumbing, exterior utility delivery, if it's not covered by the utility service, those can all be landlord obligations, and the tenant is going to want to review and make sure that the landlord will fix those things and make sure they're performing their side of the obligations. Tenant made improvements, alterations, and trade fixtures. Again, it's pretty standard. Anything you build or add to the building becomes part of the fixtures. It becomes part of the real property. You can talk to your lawyer a little bit about specific examples of equipment or some type of modifications that add value to the building, and do they become part of the real property that the tenant can't just rip out and take with him when he leaves. You have to specify if it's custom for their use in their business or that sort of thing, or whether it's easily removable. Signs, again, this can be kind of a bigger deal, maybe not so much with industrial. They're going to want to maybe put a sign on the side of the building. Most landlords don't care as long as it's compliant with city code. They're not as concerned. Like on a retail building, signage is really important. People want big, gaudy, eye-catching signs to draw tenants in, and the landlords may not want that, and other tenants also may not want that. Condemnation here, again, this is something that will definitely start to come up when you get into the, I'd say, 50 or 75 properties. And it basically regards what happens if a local or state municipality takes an edge of the land. And for a building like this, it's most likely going to be a parking lot, it could be a driveway, and it could have a real implication if it narrows your truck court. So parking for the tenant, is really important, and so there are mechanisms to reduce the amount of monthly base rent as a pro rata basis of what was taken. And as well, if there's a percentage of the land that is taken by the government entity that exceeds a certain percentage, well, the tenant has then the right to terminate the lease. And so just because there's boilerplate in there, I think everybody should understand it. You should take a look, but just know that it occurs, but not that frequently. Maybe it depends on where you are, but if they're wanting to widen the road in Texas, they may take a significant part of your land, and that reduces the value to the tenant. Assignment and subletting. Again, we see that a lot, but for single tenant buildings, unless the tenant is struggling, they're probably not going to need to sublet. Sometimes if they're not using all the space, they may have a opportunity to sublease part of their space for an incredible profit. And so this one doesn't have language. Let me see if it does. A standard one is, okay, here. So if the tenant subleases for excess rent, they will pay 50% of that gain to the landlord. And it basically just prevents the tenant from making the benefit of the bargain and kind of advertising or soliciting more tenants to come in. They're not going to be able to run a business of subleasing out their space. That's not what the landlord wants. They're expecting a single tenant to come in to be the user. They're not looking to be another middleman over subtenants that they have less control over. But they will still give them the benefit of the bargain if there's a percentage of their lease space that they're not using. And again, the market for these rents has gone up tremendously. Landlord says, okay, you want to rent this out for double what you're paying me, we'll split that gain 50-50. It's still worth it for you if you're not using the space, and it's still worth it for me where you're not going to try to be incentivized to make a business of it. Indemnification, again, pretty standard. I think you just want to read it and understand that the tenant indemnifies the landlord in pretty much all scenarios. Inspection and access, 24-hour notice. Again, these are rules that are sometimes minor, but it can really disrupt operations if you don't understand what the notice could be. Nobody likes the landlord poking around in the inside of their building, but as long as you have 24 hours notice, I think it's reasonable for the tenant to consent to that. And again, later on this lease, you probably want to specify one contact person within the tenant and the landlord organization that is responsible for receiving that notice. It's not just enough that they send a letter or they send an email to the real estate department that signed the lease. Who do you want to be your point of contact to let everybody know on site that, hey, the landlord's going to come tomorrow or the day after tomorrow? Quiet enjoyment. This one is a pretty short paragraph, but it is pretty important. This is an obligation by the landlord to deliver quiet enjoyment, and this can be all sorts of nuisances from sound, other noises, vibration, or smells. There's all sorts of problems, or I don't say problems, but issues with quiet enjoyment, and they cover basically all the 5 senses. So what is that? I don't know about vision, but it could be like a smoke. You could have some type of steam coming across the property that affects visibility in the truck court, visibility outside the building, that affects their ability to do their job. So you have visibility, sound. We talked about noise. In an industrial park, it's probably going to be a pretty high standard, but I could still see something that exceeds it. So if somebody is running like a jet turbine and you're just trying to run diagnostic equipment and it can't function, again, due to the vibration plus the noise, that quiet enjoyment is prohibited. I don't know about touch, sensory, but those are the major, maybe not taste either, but who knows? You could find a way that says there's a taste on my tongue that's unacceptable for my employees. All right, surrender, again, just promises that the tenant will survive, will surrender the lease premises at the end of the lease. If they're holding over, then there's a 200%. That one is kind of high. I think this might be landlord friendly. I think a common middle ground is 150% of the base rent of the month prior to the holding over. Default. This is an important section. You want to spend some time on what constitutes a default. Do you have a universal cure? Do you have a monetary cure period? That can be something like 5 days after written notice from the landlord. They only have to give that warning once. But for monetary defaults, it should be a shorter cure period if you're going to put anything in versus a universal cure period, which is any other type of default. Let's say it's a violation of the permitted use. Let's say it's a parking violation, modifications to the building. That can be a default in and of itself, but it's non-monetary. It doesn't have to do with paying rent. And so there should be a little bit more generous terms of default for non-monetary. And so just go through it and understand, if you're not maintaining insurance, let's say you're a day late, is that a default? Eventually it will be, but usually the landlord will have to give you written notice after those 10 days and you still haven't obtained insurance, then they can put you in default. Again, HVAC, ADA modifications, they're allowed to post a for lease. This is at the end of the lease term. Landlord remedies, they're going to have a lot. They're going to be able to lock you out. They're going to be able to take possession of your inventory, auction off any valuable goods inside, pay you the delta. But there are procedures that the landlord has an incredible amount of discretion and flexibility to exercise one or more of these remedies and not an acceptance or surrender of the premise. Again, there's not that much flexibility here, but the landlord really has broad permission to lock out the tenant, take possession of the property, the personal property inside the premise, and auction it off and try to recover any value from that property. So it's really critical that if you have a few $100,000 worth of inventory inside your building, don't be late on your rent because the landlord's going to have options to lock you out and take title to that property. There's some exceptions for security claims that are exempt from that, and we can talk about that in another video. But if there's a specific loan on a piece of equipment within there, the landlord can consent to not seize property that is secured by a third party, and that would be a contractual agreement that the landlord would sign at the time of the borrowing of the loan, basically, for this property. So again, you may have a forklift inside the building. It's not free and clear. It has a loan and a security charge by a third party. The landlord will sign a consent that says, I acknowledge and I give up my security claim against that piece of specific property because they acknowledge the third party lender. That's something that's common, definitely comes up if you have a tenant who is borrowing to purchase equipment. Again here, subordinate to the landlord's mortgagee. We're going to talk about that in another video, the SNDA, that's the Subordination Non-Disturbance Agreement. Here, subordination, you're essentially agreeing to it in the lease, but an SNDA is a separate document that is signed between the tenant, the landlord, and the landlord's lender. Kind of governs what happens if the mortgagee, the mortgage landlord, forecloses and takes title to the property. The tenant then, becomes a tenant of the bank. And what are the terms of that? Because the bank has not signed this lease agreement, but the SNDA governs kind of how they would transition if the lender forecloses and becomes the landlord with, no default by the tenant, right? Estoppel certificates, this one's pretty important. I think that the ideal lease structure will put a form of estoppel certificate in the lease that the tenant has reviewed and says, I'm okay with this form. I'm willing to sign this form in the future during the duration of this lease. Because otherwise, what I see a lot is when you have just this obligation to deliver within 20 days after landlord's written request, there can be reasonable disagreements about the form and the content of that estoppel certificate. And if they don't agree to what the words of the estoppel certificate are, the tenant is kind of in a tough spot, and so is the landlord. You say, the tenant says, I am willing to sign a estoppel certificate, the one that we agree to, but not the one that you have sent me. And I don't think it's clear on who should provide the form, because the lender, they kind of have their form, but it's kind of hard to predict what the lender will want in the future, let's say if there's a refinance. So it's really kind of a chicken and the egg. You as a tenant don't necessarily want to agree to any type of estoppel in the future. At the same time, the landlord says, well, I can't predict what it's going to be. I just want you to promise to sign one. And so that's where you come up with this form of estoppel and say, look, at least the tenant is willing to sign this one. Let's send it to the new lender and see if they will accept it. But that's a really good way to kind of clarify. And again, that's protecting the tenant more than I would say the landlord, because you can have a reasonable doubt. But at least if the tenant has agreed to a form of estoppel, then they're willing to sign something, and you can at least present it to your lender and try to negotiate for an approval, versus if the tenant just says, nope, I'm not going to sign anything. So environmental requirements, again, this is important, but you really want to look at their use. In general, you as a tenant just have to agree with all these things. The landlord is not going to have much duty to review or research your actual behavior. It's more kind of after the fact. Only if a third party comes in and makes allegations will the landlord invoke these clauses. Here, third party will notify landlord or tenant about environmental issues and costs. They're going to indemnify. Environmental is a big deal, but I think people don't put a lot of time. I certainly don't modify the environmental clauses very often. We just kind of review them and understand that we don't have a lot of negotiation power, because we're the tenant. We should be responsible for what happens to the land. Independent covenants, pay all rent and sums due. That's important. They do this, but we're not providing any security. This is kind of a new clause. I've seen this a couple years ago. Maybe I'm dating myself, but like 5 or 10 years ago, we started putting new clauses that says the landlord is not providing security for the tenant. The landlord is providing a security service for the protection of the building for the landlord's benefit. And it was really interesting because we had some of these lawsuits where security was patrolling a parking lot, and a office tenant, like a lady was walking back and she gets assaulted or she gets robbed, and they had security and they said, you're negligent, your security didn't do anything. They saw the crime and they were told not to interfere, and they could have prevented this, but they didn't. And so in the lease they said, landlord is providing security for the tenants, and so they've switched that now. So I think it's kind of interesting that they're providing this security, but it's not for you, it's for the building. Force majeure, again, we've seen some. This particular lease doesn't have a COVID specific exception for pandemic or other health issues, but this is kind of just a boilerplate force majeure. And it's interesting because force majeure really should cover things that are unexpected, things that are outside of our predicted realm. But once you identify COVID, and once we know that there could be something like a pandemic occurring, it exits the world of force majeure because it's predictable. It's foreseeable that we could have a COVID type incident again, and what do we put in the lease? So we need to address it with a specific COVID clause or a pandemic or health related emergency. That sort of thing really should be for COVID. Entire agreement, no outside evidence. This one's pretty important. I think a lot of people kind of gloss over this, but any representations, even if it's in writing, you could have an email from the broker or an email from the landlord that says, oh yeah, we will also give you reserved parking at no extra cost. It's not going to be enforceable. Even if it's in writing, this lease supersedes any other representations, and you are SOL no matter what somebody says outside of this lease agreement. No reserved parking, that sort of thing. You lose. Go straight to jail. Brokers, again, I typically want to see it that you either have no brokers or you are agreeing to pay according to a separate agreement. We don't like to get into a broker fight within the lease, especially because maybe this lease gets recorded or filed for public companies. So that's a pretty standard thing. Either we represent no brokers or we identify the brokers and they're going to get paid. Tenant agrees to indemnify if some of these brokers on the tenant side sue the landlord for payment. Tenant is saying, well, I'm introducing you, so it's kind of my fault. This is kind of a follow-up. Landlord's lien security interest. That's similar to what we were talking about earlier. This is related to filing under the UCC. Again, probably worthy of a video all on its own, just about the security interest that the landlord has. Some tenants push back on this, so it's probably useful to understand how valuable it is to you as a landlord. Miscellaneous, tenant, broad description. Notices here, certified mail, fine, or by FedEx, postage prepaid. This one may cause some issues. I don't know. There's people that will push back on hand delivery, and I kind of am sympathetic to that line of approach. I don't like hand delivery. It still creates too much ambiguity just because some property manager says that they handed a document to somebody at the property. I don't like that. I would much prefer tracking for everything and not allow either party to try to claim that they did hand delivery. So I would prefer, email plus mailing, but no real hand delivery. And this one is already updated. I've gotten rid of fax, right? It's not acceptable to find some fax number online from 6 years ago and try to fax a notice to somebody who doesn't get it. No faxing. I like no hand delivery and stick to email or something with tracking. So here, we have financial statements. These are some affirmative obligations regarding the tenant. You can decide whether you want just like a compilation or if you need audited financials. If this is a big company that is already preparing audited financials, why not send all your landlords an extra copy? It's only really if they're already getting audited financials, because if they're not, it's pretty big expense. But if they are obtaining those, ask for a copy and you have a higher level of certainty. Submission by the landlords, no binding effect. Gender, that's pretty standard. Within 10 days. So this is kind of a 10-day grace period. It's more generous than some of the leases that are at 5, maybe 3. But 10 days is nice. I think they're reasonable. It's more about the duty on the landlord, right? So if they don't get paid after 3 days, they kind of have to turn around and jump on sending a notice to the tenant. But if you give it 10 days, most tenants are going to pay, and only by the 15th
is the landlord really going to start to get stressed and start to respond. Time is of the essence. That means that all the dates are the dates, and it's not just a general indication that has to be performed within that time frame. If there's a personal guarantee on the loan, guarantor will perform all these things. That's a separate exhibit, but it's very clear that it's included as an inducement for the landlord to sign. Signature pages are separate, LLC, you got to have this. The signature block is actually pretty critical. For all of our landlords, we do review the tenant formation documents and operating agreement to make sure that this signature block is proper authority to enter into this lease. It's an important issue, because if you're ever into litigation, they can claim that the person signing didn't have authority to bind the company into a lease. For the landlord, again, if you're the tenant side counsel, you want to make sure that the landlord has proper authority for the deed record owner, but you want to just look at some of the operating documents to ensure that the signature block is accurate and they have authority to enter into the lease. Rules and regulations, again, these are all pretty standard, but you want to read it. No dogs, cats, fowl, or other animals. Well, what if your tenant use is some type of veterinarian or some type of medical testing where you do have mice and cats? Is that a violation of number 5? I don't know, but you want to make sure your rules don't, on the face of them, violate your proposed use. None of the parking, truck courts, have any rubbish, trash. Pallets is a big one. If you need to have pallet storage outside, make sure you clear that with the tenant, and maybe we put that in the lease explicitly that pallet storage shall not exceed 6 feet high stacked in this particular crosshatched area, not to exceed 50 square feet of this area. So really important that you don't want to be in violation of the rules, and you don't want to start the relationship on a bad foot. I think that tenants who understand what their use is going to be, and tenants who review the lease for immediate violations and they raise that to the landlord, that's starting the relationship on a good foot, because the tenant says, hey, I'm aware, I respect your rules, but I see myself in violation. Is this okay? Where should I stack pallets? And that's really all it is. It's about communication. I think 99% of these tenant landlord issues could be resolved with just proactive communication. So no parking, no disrepair. This you can talk about, but it's more particular to your use, because in general, you can have this written notice, but you could also put a time frame. If somebody gets a flat tire, okay, maybe they get 48 hours to move the car. That's reasonable, but here it's just written notice, so the landlord's probably not going to send a notice until a couple days anyway. Movement, no floor covering, cement. You don't want to damage the concrete, especially for like a newer build. It's removal of that cement that's going to cause the issue. Laying the floor covering is not damaging, but when they want to remove it, that's the problem. Again, signage, any of these things. Description of the property, again, this is where you're going to want the legal description. Really critical that you have it match exactly what the real property is, and it can be confusing if you have just a street address, or if you're in an industrial park and there's a lot of buildings, it's not really clear what the address is, or they could have multiple addresses on a building. Depiction of premises, I don't have a sample here because it's really specific to the building, but this is basically going to be a drawing with a crosshatched area, or it says this is the building outline and the BOMA standard square footage, and you get everything if it's a single tenant type situation. But this will have a crosshatch, maybe it's divided into 2 spaces, but it'll have a crosshatch of what your leasing area is. Broom condition, this one's important. It just talks about all the equipment, it talks about repair, and it really just puts more definitions about what does broom clean, what should you leave the premise, what are you going to receive the premise in. Door lock, all dock bumpers, if there's any equipment, signs shall be removed when you move. Exhibit D, tenant work. So this is in the extent that the tenant will do the tenant improvements themselves, but the landlord will not reimburse for the TI amount until all of these are completed. Affidavit from tenant, unconditional lien waivers from their contractors, all permits, invoices, and the full payment of rent. You really should understand when you're going to get paid. I think tenants ask me that a lot is, okay, we've done all the work. When are we getting paid? And I say, well, you need all these unconditional lien waivers. Okay, you need this affidavit. And they're saying, okay, geez, well, we have 4 out of the 6, but not quite there yet to submit it to landlord. And even when you give it to them, they have 30 days after they receive all 6 items. Guarantee, this is what we talked about earlier. If there is going to be a personal guarantee or maybe a corporate guarantee on this lease, if you have a newer company where the parent doesn't have that strong of financials, you may issue a corporate or a personal guarantee in favor of the landlord. It's unconditional guarantee. You can have some limits on this. One thing can be the distinction between base rent obligations as well as triple net. So let's say that you sign this 7-year lease and you only want to do a guarantee for the base rent, because after year 5 you may vacate the premise and then there's only 2 years left on the lease, but it's cheaper to just move out of the property, pay your base rent, and not pay any of the triple net. And so that's really interesting because it reduces and it makes it a lot easier to calculate. This location is not profitable, so how much do we owe for the remainder of the 2 years lease? We'll pay that, but we don't want to pay any other expenses. No labor, no utilities, no delivery, nothing like that, but just guarantee the base rent and make those monthly payments, as opposed to guaranteeing all sums due under lease. So that's an interesting way that you can guarantee it, and just, reduces the cost. But I think the main thing is it provides certainty. If a location is no longer profitable, how much does it cost for the last 2 years or maybe year and a half of just base rent amount? It's very easy. You can just calculate it with no variable, no variations. So you can limit that there. Applicable law, Texas, attorney's fees. It's all pretty standard. Waiver of jury trial, guarantor has some information. Social security numbers is really critical. And that's it. I think I've walked through this lease. Thank you for your patience for over 30 minutes. I'm going to put some chapter breaks so you can jump to specific clauses. But if you've made it this far, hats off to you. Feel free to drop a comment or reach out if you have any questions. But this is really a great base lease, and it should give you some idea of what you would want to change for your property, for your particular tenant, and your landlord goals. So thanks for watching. Smash the like button, and we'll see you next time.